Now, one person we did hear from today for the first time, Karen Reed herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, how is everybody? Boy, do I have a flippin' good show for you today. My guest, David McKenzie, is a criminal defense lawyer who has tried over 250 criminal trials, including approximately 50 murder cases. He has won more awards and accolades than I have time for in this introduction. In addition to teaching continual legal education for the Oklahoma Bar Association, Oklahoma Criminal Defense Lawyers Association, Mr. McKenzie is also the on-camera legal analyst for KFOR Television in Oklahoma City. He has represented such high-profile clients as Julius Jones, Paul Housekiller, and Colin Griffith. Welcome back to the podcast, David McKenzie.
Hey, Roberta. It's good to talk to you.
Good to talk to you. So let's start off with, I guess, what is a pretty controversial case. Colin Griffith, who, when you represented him, he was a 15-year-old teenager accused of killing his father, Charles Griffith, and he's now been acquitted in Florida of stabbing his mother, Caroline Griffith, to death. What's it like to represent a client that goes on to be accused of, I guess, the same kind of crime?
Well, I haven't seen Colin in 2 or 3 years since the incident with his mother, before the incident with his mother. The incident with his father is a very tragic story of years and years of physical and emotional abuse. I can't tell you a whole lot about what happened with his mother. I did know her as well, and that was a tragedy in and of itself. He now, I believe, is 18 or approaching 18, and is kind of a mild-mannered, quiet kid in my experience with him. Very intelligent, soft-spoken, polite. But again, I haven't seen him in, it's probably been at least 2 years.
So he's the quiet ones. He's the quiet ones. But I mean, I guess what I'm asking is, do you think to yourself, you know, if it weren't for my profession, I mean, how did he get acquitted in they dropped the charges? First they brought the charges, then they dropped the charges. Did that have anything to do with your lawyering, or was that lucky, or how did that happen?
No, that had nothing to do with lawyering. Also, Shelley Levisay is involved in his defense, and she's actually lead counsel. When this happened, Shelley had been representing the mother and trying to get Colin back from his father and move him down to Florida. They never filed charges on him in Oklahoma. I think they determined that it wasn't a prosecutorial or a case that could be prosecuted beyond a reasonable doubt because there was so much evidence of self-defense. I've never seen any police report. I haven't seen crime scene photographs. I know it was with a firearm that he shot his father at least twice. And since charges were never filed, none of that stuff ever went out to the public. So I think they just made the decision not to prosecute because it appeared that he acted in self-defense. Now, I do hear rumblings that they are reconsidering possibly filing charges against him. And I hope they do not. That would be unfortunate, but Ms. Levasseur has been in contact with him, and we are ready and prepared to defend him should those charges be filed in Oklahoma.
Okay. Yeah, that's what I mean, because everybody is rightfully, I mean, I'm just reading the media stories on the case. I don't even know if the trial was broadcasted, but everybody's up in arms because he said that the mother fell on her knife, fell on his knife, which sounds like that we both reached for the gun defense. Mm-hmm. It's hard to just hearing that and saying, you have to think that the defense brought some pretty questionable, compelling evidence for him to get acquitted. No,
I would assume so. I saw a few clips from court TV. I guess they must have shown something about it. The defense was that of self-defense, and I read in some article that his lawyer had said that the mother basically had her acts were just an attempt to commit suicide. And I don't know what context the facts fit into that particular statement, but a lot of mental health problems on both sides of Colin's family. I knew her. She's a very nice, pretty lady. But when Colin was born, she was just barely 14 years old. So obviously there's kind of a bit large backstory there that I think if they do charge him in Oklahoma is going to come out.
And last time we were talking about Julius Jones, was that a high-profile case when you represented him, or did it just become, because he got the death penalty years later, a high-profile case because it became a cause? Was it high-profile at the time that you defended Julius Jones?
On the local level, it was high-profile. All four television channels would be present at a lot of the hearings, and there seemed to be, if I remember correctly, a lot of television coverage during the trial. Now, in Oklahoma State Court, they do not allow cameras into the courtroom. So and there would be impromptu press conferences after we walked out of court. Cameras would be around. During the heat of a trial, you're not watching the news to see how much coverage there is. But it was a substantially large case and drew a substantial amount of media coverage, just local. The national stuff came out, years later when it became some kind of cause celeb.
So do you think cameras should be in courtrooms across America? Do you think it's a good thing to have cameras in courtrooms?
I don't think I have an opinion one way or another on that. There's a lot of criticism from the O.J. Simpson case that cameras in the courtroom led to a lot of showboating by the lawyers on both sides and that type of thing. I don't know if it prolonged the process or what exactly it did to make the process not as straightforward as it should have been. But I see that they have their place. I think that the public has a concern in seeing that trials are run fairly and justice is meted out fairly. And Obviously people aren't going to sit around and watch every case that goes through, but I think there are a few cases that maybe cameras in the courtroom would possibly benefit. So,
Like what kind of cases do you mean?
well, I think cases where there's a lot of public interest sometimes, cases that don't involve like children victims or sexual assault victims, where you want to try to protect the privacy of the victims in the case, but also, you have the constitutional guarantee of open and public trial. So I think it has to be measured with the rights of privacy of some people. And but your question was what types of cases? I I think the Julius Jones case would have been a good case for trial, for television for trial. It involved snitch witnesses, people getting deals. Um, it had some good lawyering in it. Um, I think that the judge in the case probably would have done a lot better job if there were cameras in the courtroom. Um, it's it's hard for me to say. I've never really been asked that question before. The first murder trial I tried, though, Court TV wanted to televise that trial, and that was back about 1996 or 97. And it was a battered woman defense, and the judge would not allow Court TV to televise the trial, which is under Oklahoma law. All parties and the judge have to agree for cameras in the courtroom.
And you think that would have been a good one for Court TV? Are you happy that it wasn't broadcast, or you think it would have been or were you? I mean, were you looking forward to it? I mean, had he said okay, would you have been looking forward to that, or no?
My concern always is with my client, and so I would never want to do anything that would hurt the client. And if I perceive that putting cameras in the courtroom might do that, I would be against it. On that particular case, it didn't really matter to me whether it was on television or not. It's the most dangerous place to be in the world is between a trial lawyer and operating a television camera. So we like to be on TV. We liked that kind of thing. But the overarching interest that we have to protect is to make sure that our egos and our desire to be recognized does not hurt that of the client.
So you wrote this article, Lights, Camera, and what was it? What's the
Lights,
actual?
cameras, bar action, I think.
Bar action. I was missing the bar. Okay, bar action. And was that you? That was your co-writer who was obsessed with the O.J. Simpson case? Was that you, or was that your co-author?
Well, I think we both were, because that's the celebrated case that was on trial. And we still have a few, but as far as gaining, everybody watched O.J. And lawyers, that article was written for lawyers, particularly watched the O.J. trial. And, and superimposed upon being on television or making statements that are outside of the courtroom regarding a case is your ethical obligations to not prejudice the judicial process and the deliberative process of the jury. So I'm sorry.
So I'm just going to put it up for my audience to see. If you're listening on podcast, these are your 10 rules for lawyers in concerns with the media, dealing with the media. Read the state rules of professional conduct for lawyers. Consult the client. Do your homework. Be professional and considerate. Always assume you're on the record with a journalist. Never say no comment. Why not? That's something we hear lawyers say a lot. No comment.
Yeah, because it's a lot of times that sounds like an admission. I've had times when I'll just walk on by and won't say anything at all when asked a question. But it can be taken as um, is I'm admitting that my client did something or said something. So I'm always careful with the no comment thing.
And your body language. So what does that mean? You just don't want to look defensive, cross your arms and look defensive in front of or like you have something to hide, have kind of open body language. Is that what you mean? Be aware of your body language?
Yeah, just like in casual settings, you want to have, the appropriate body language and not, not be over dramatic, that type of thing, to try to get your point across without being distracting.
And don't talk like a lawyer. Yeah. So I think that's self-explanatory.
Yeah.
Keep it short and sweet. That was a problem we had in the Karen Reed case. The prosecutor had a really long, he had a lot of evidence to get through, and he put it all in his opening statement. Review statements prior to publication. Mm-hmm. And that's, so before you publish something, make sure it's okay. It's not going to prejudice your client. That's what you mean?
Well, you want to, if you're going to say something, you want it to be accurate. Don't be saying anything that's inaccurate. And you need to carefully think through what you're going to say about the case and about your client, so it doesn't hurt them in the end.
So what do you think about, so the last time we were talking about Julius Jones, and really what was my area of interest, and still is usually post-trial litigation, meaning innocence fraud campaigns that are done by lawyers in conjunction with Hollywood to try to get people off, like we saw with Julius Jones. And we had 2 Innocence Project lawyers produce their own ABC special, The Last Defense. Half of it was about Darlie Routier. The other half was about Julius Jones. And they said at the end of it, if they only could test this bandana, they could prove Julius Jones's innocence. Then after the ABC special, they did test the bandana, and it came back with Julius Jones's DNA. And they still went on with the Innocence Fraud campaign. The Innocence Project didn't drop Julius Jones, didn't walk away from him after he came back with his DNA. They just sort of acted like it didn't happen. So with Karen Reed, this is a campaign very much like Julius Jones that's happening pre-trial. Mm-hmm. Have you ever seen anything like that? A kind of campaign by lawyers and bloggers and journalists, sort of that's hyped up pre-trial?
I think in the O.J. Simpson murder trial, yeah, it was a little bit like that, but I don't believe you saw it on the part of the prosecution. It was more, it gained such national attention, and almost immediately there was the Vanity Fair article regarding Mark Fuhrman and racism, and it sparked such interest that it seemed that they're getting everything out there that they can, because they probably knew that their jury was going to be sequestered at some point. And I will tell you, all that is highly improper. You're not supposed to prejudice the jury. You don't have to, you can reply to things that are said and defend yourself to a certain extent, but to just go crazy talking about credibility of witnesses and things like that before their credibility actually comes to issue as a problem.
And then we also have 19 witness harassment counts against a blogger that they used to leak information to. And so they would leak the information to the blogger, and then they would reference in their own motions, which is another technique that they use, which is they hype up the supporters of the accused through their motions, because their motions are broadcast on TV, hearings for motion, whatever. Actually, I can show you one of them in a second, but they, so they're also involved in so they would go to witnesses at houses and, go to their kids' ball games and scream at them, accuse them of being real killers. That's what, Massachusetts has basically turned into, I don't know what people have referred to it as the Salem witch trials. I don't think that's maybe the best analogy, but it's just kind of a the whole state is obsessed with this case, and they brought in people who are witnesses in the case, and ruined their lives basically for just being a witness in a case. It's wild what we're seeing. But one of the first things I want to talk to you about is they let Karen Read do a whole bunch of interviews, and I want to show you just a clip from one of them. Would you? I don't know what you're going to say. I really don't know what you're going to say about any of this. So I'm just curious to hear your opinion on whether you find this helpful to Karen Read's cause. Here's Karen Read talking about her case.
Did I hit him? And when O'Keefe's body was discovered, first responders who arrived on the scene say they overheard Read make other statements.
Firefighter said that you said, I hit him, I hit him, I hit him.
I said I hit him. It was preceded by a did and proceeded by a question mark. What I thought could have happened was that did I incapacitate him unwittingly, somehow, and then in his drunkenness, passed out?
When you walked out of the bar, how many drinks had you had?
I had probably about 4.
The Commonwealth says that you had 9 drinks that night. That's what the prosecution says.
I don't believe they're saying I wasn't in my right mind.
No, they were saying you were intoxicated. Is it possible that you might have hit him unwittingly in your admittedly very large SUV?
No, not possible.
3 days.
Okay. Just, I mean, if that were your client, what would you? Would you let? How much is the client going rogue, and how much? I believe that her lawyers were there during that interview. What would you do if that were your client?
I would, never have them speak in a television interview for a lot of different reasons. But you're stuck with that story, and it's giving the prosecution a preview of what you're going to testify to. And if you don't testify that way, it even hurts you more. So I think it's always best to allow the client to sit through the trial, hear the various aspects of the testimony and the evidence that's coming in, and see how it plays out in real life, and then have them, tell their side of the story. Now, the broad brushes of what happened, but as far as the real pointed details, you don't know that. Also, with a television interview like that, well, let me give you an example of something that happened to me in the first murder case I had that I was telling you about. It drew a little bit of local attention because this woman had shot her husband in the back of the head, and the media, or at least one of the television stations, thought it was because she had a bingo addiction, that she was blowing all her money on bingo, and she was trying to get life insurance policies or whatever. And so I think this is like the first television interview I ever did. The reporter comes into my office and she asks several questions. And one of the questions she asked was, why did she play bingo? And I said, well, I really don't know why she played bingo. I guess maybe for the money and the enjoyment of it. And when the story comes out the next day, my answer is played, but there's a voiceover, and the question was, why did she kill him? Not why did she play bingo?
Oh,
right.
Boy.
So you have me answering why did she kill him with, well, I guess for the enjoyment of it, or maybe the money. So that is why television could be so dangerous.
Right. And so the unedited, and she has told different stories all through this. She's changed her story and she's changed her defense. And all of this is coming into trial. How do you deal with something like that? A client with a changing story, shifting story?
Well, it's very difficult to deal with. Sometimes you just can't. If they keep, changing the story and coming up with different dynamics, it becomes more and more unfeasible to get an acquittal because, You know, innocence should always be one straightforward story. If it's self-defense or some other guy did it, or what it is, and when you start bouncing around, going various places, and telling different stories, you've got a problem. And all of this is memorialized, I guess, in these television interviews, which will be played in her trial when she is being cross-examined. Now, I'm assuming, I'm sorry.
No, go ahead.
Well, I'm assuming she's going to take the stand. Maybe she's not going to take the stand, and they hope to sway the jury before they're even summoned to the courthouse. Now, I think that's a dangerous game to play. For one thing, if you're relying on somebody remembering exactly what they heard on TV for a defense, you've got a problem, because they're not going to probably remember exactly what they heard. And the second thing is, you know, they can take these without her taking the stand and use them against her in their case in chief, meaning the Commonwealth of Massachusetts.
And yet she didn't take the stand. That was before her first trial, and she didn't take the stand, but she's very comfortable doing a lot of, we saw her after court every day giving statements. First, I mean, not good statements either. They asked her if she ever loved John O'Keefe, her police officer boyfriend that she's accused of murdering, and she said, no, we were dating. Meaning, no, I didn't love him. We were dating. I mean, that's can't be helpful, no?
No,
I mean,
no, I don't see anything. I don't see anything helpful from what you just said to me, and from watching that clip.
Right. This is such a bizarre thing, and so and that's one thing you mentioned is this, you know, the story should never change, and yet it looks like, just by the filings we're seeing in the second trial, that the defense might go a whole nother way. So let me just show you what they did in court. Hold on one second. I have so many clips up wanting to show you, but I just want to show you this one where how they use their motions to telegraph their defense to their supporters, and so this is something they never did in trial, but they did in hearings, which is name other people, because they could never really establish a third-party defense. The judge left it open for them to develop, but they could never really develop that, because there's no evidence of it that someone else did it, but they did it in their hearing. So here's David Yannetti. He's a pretty prominent lawyer in, yeah, here it is. Is this what I want? Yeah. Okay. Here we go. Talking about Colin Albert and the other people that they want to accuse. Here we go.
Office that afternoon, I had already begun to learn that this wasn't just a tragedy, and it wasn't just that my client had committed no crime, but shockingly at the time, I learned that somebody else did, in fact, commit a very heinous crime. A friend and colleague of Brian Albert's called me on February 2nd, 2022, only hours after my client was arraigned, and named Brian Albert and his nephew Colin Albert as potential suspects. That tip on day one of this case led us to do the investigation the Commonwealth did not do, the investigation they refused to do. And as my co-counsel has argued today, that investigation revealed that the Commonwealth's investigation was based on one lie after another.
So this is something that they've done over and over again, which is promise things that they can't really come through with. You know, they've promised that they'll prove. So this was someone who was in law enforcement who had been reading the blog. So the way the defense works is they leaked it to a blogger. The blogger, their defense ideas to a blogger. The blogger wrote it. Then they would refer to these as it's been reported as facts in their motions. Mm-hmm. But they never. And this one guy came in and they said this tip that he's talking about. The guy came in and said, "No, I read it from the blog." And he handed back the money that they were going to pay him to be a, private investigator, work on this case. excuse me if I can't remember the details, but he wanted nothing to do with the defense. But here they are presenting their emotions like they have this great witness or they were given this great tip.
I think what that motion sounds like, they may be responding to a prosecution motion not to be able to bring up the fact that somebody else may have done it, because the law of most states, and especially in Oklahoma, is you have to have some sort of evidence of that and able to present that motion. It's commonly referred to as a Saudi defense. Some other dude did it. And I mean, you can't just throw it out there without having at least a little smidge of evidence that there was some another perpetrator. But the problem with what he is saying is that, you know, it's based upon just rank hearsay and botched investigation, that type of thing. So I think he's probably struggling to be able to allow the judge to let the jury hear the somebody else did it defense. But it doesn't sound like he's getting there.
Yeah, but it looks like they're going from one person to the next. Now they've totally abandoned those people and gone on to someone else they're accusing. At second trial, is that a good idea to change your I mean, have you done a retrial before? Have you had a hung jury and had to defend someone again in a retrial?
It's very difficult to do that because you lose a lot of steam after the first trial, and it really kind of loses a lot of its sex appeal. So I hate to try a case twice. So as
what do you mean sex appeal? What do you mean? What do you mean sex appeal?
You lose your. At least I tend to lose the enthusiasm for it, the overpowering enthusiasm you get in trying a case. When you hear it a second time, it becomes more flat. And the prosecution is ready for anything you're going to throw at them because they've heard it once before. So retrials are notoriously difficult to get an acquittal in.
Yet when they got a acquittal, they acted like they won the case. You know, they were like, "This is." I mean, they were all hugging each other and giving these like really emphatic statements like they won the case. I mean, is that helpful for the second trial? Is that helpful for who's that helpful for?
I don't know if it's helpful for anybody. Maybe they just want to keep a positive attitude and a good front. But but your original question was switching the defense. That's a difficult question to answer because, as investigations go on, maybe you find out things after the first trial for the second trial. But you're not going to switch from a hung jury on a self-defense case to the second trial being somebody else did it defense. That is completely incongruent, and I think probably would be something that the prosecution might be able to bring up to the court and the jury.
And is the ultimate? Is the best outcome for your client to have charges drop before you ever go to court? I mean, is that the best outcome for any defense lawyer? Do you think?
Absolutely. Excuse me, because you never know what a jury is going to do. You can have the best case in the world, and sometimes people get convicted. Those are the kind of cases that scare me. Those cases that I should get an acquittal in are just, you lose sleep over that stuff. And the ones that are really hard to deal with are the ones where you have an actually innocent client. Which, doesn't come around all that often, but occasionally you get it. But the pressure of that's just unfathomable.
That's a heavy load.
Right.
And but it must feel good when you get an acquittal in those cases, no?
Well, I've been fortunate enough that I haven't had to go to a verdict with somebody I believed was innocent. When I say I believed, it's not because of what they tell me. It's because of what the evidence tells me, and going through it and interviewing witnesses and things like that. So again, I've never tried one of those to verdict. The case I'm most proud of is a young man that was accused of a homicide, a gang homicide in Oklahoma City. And he sat in jail for 18 months awaiting trial. And I finally, on the eve of trial, after it had been set 4 or 5 times, got the prosecution to dismiss the case against him. And I picked him up at the jail and drove him to his home, where I got to see his little girls come out of the house and jump on him. And he closed the door, and that's kind of the last I saw of him. But that was my finest moment in practicing law. They can have all the acquittals and all the verdicts and all the fun from being successful in that, but you've really done something if you can help somebody not have to face a jury trial and get to the ultimate truth that they are innocent.
Yeah, that must have been a good feeling.
It was a great
So
feeling.
another thing is that's come up in this trial is the coziness between Karen Read and her other very Hollywood, speaking of OJ, he's a California lawyer, Alan Jackson. So wait, hold on 1 second. Okay, here we go. This is from Inside Edition. It's a report on Karen. Actually, I can make it even bigger. Hold on 1 second. There we go.
Internet brouhaha. It involves this unverified video where she's being tightly embraced by her lawyer, Alan Jackson. Karen wears a sleeveless shell and tight jeans. Jackson hugs her from behind. He has one arm around her neck, the other around her waist. One key Karen Read supporter says in his opinion, it's not a romance. It looks like Karen Read was about to wander into the picture, so Alan Jackson held her back. She and Jackson had dinner earlier in the evening with others. I asked her about the video today. Any comments on the video she's circulating with her lawyer?
Okay, so but he's also been seen recently with having drinks with his elbow on her leg. So
Yeah.
do you think that you can get too close to a client like that? Is that getting too close regardless of, he's a married man.
Well, the rules of professional conduct prohibit lawyers being in a romantic relationship with their clients unless that relationship started before representation. You can have a relationship after representation, but during representation is highly inappropriate. I don't know what Mr. Jackson and this young lady are doing, but they're sending out a very bad signal.
Right. Yeah. It's not a good look.
It's not a good look.
Right. Yeah. Speaking of not a good look, there's also this, which is raising funds via a raffle with what I've heard. I haven't fully done a full research into Massachusetts law, but a questionable raffle, let's say, that may not be too legal in Massachusetts, spearheaded by Alan Jackson. Take a look at this.
Hi, it's AJ. I wanted to take a quick second to thank all of the supporters who have given us so much energy and boosted our morale for so long in defense of Karen Read. Both Karen and I and the rest of the defense team could not do what we do on a daily basis if it weren't for you folks. And we want to take an opportunity to thank you in person, to have a unique opportunity to have a dinner with you, to have a conversation with you, to let you into to sort of behind the scenes of what it takes to build a defense like this, what it takes to continue along the track that we're continuing, to have that no quit attitude at all times. And I'll tell you a secret, it comes from you guys. So I'm looking very forward to meeting some of you in person, to sharing a nice intimate dinner with you, to answering your questions, and really having a dialogue. But the main thing is to thank you for what you've done, what you continue to do. We couldn't be here if it weren't for you. We wouldn't be here if it weren't for you. So on behalf of the entire Karen Read defense team, thank you so much, and I look forward to meeting you in person.
Okay.
Is that an effort to raise funds for her defense?
$50 raffle, but it was done on her private Facebook group, and strangely only supporters won. No non-supporters strangely won that raffle. So I mean, have you ever seen? I've never seen anything like that. Have you? I mean, just in my time looking at trials.
Yeah. Well, I see a few things occasionally come through that I've never been involved in, or do I know any other lawyers that have been involved in it? But like GoFundMe pages for people for, to help them with their defense. I think there was some of that in the Julius Jones stuff. Towards the end, they may have been trying to raise money through, for whatever reason, I don't know. So it's usually that one's, I would call what Mr. Jackson did there a little bit tasteless, because you're going to have dinner with a supporter and talk about trial strategy and what your client's going to say. It's highly inappropriate, and that is the impression that he gave. I don't know if he meant that, but
right. What does that mean to go behind the scenes of the defense? I was like, what are they going to do there behind the scenes of the defense? I mean, he's certainly giving the impression. Obviously, I wouldn't think they were going to talk trial strategy with their supporters, but he does, right? He does give that impression. Yeah, this is one of the most bizarre cases I've ever seen, and if it works, we're going to see a whole lot more of it. If she gets off, I don't think it will ever. I don't think it's going to end at the second trial. Julius Jones. The last time we talked about Julius Jones, he was raising something like $30,000 a month, selling sneakers and T-shirts and stuff from prison after his death penalty punishment was reduced to life without parole. What happened with that? I mean, have you heard about how Julius Jones is, or did they shut that down? That kind of his business he basically had going in prison?
I have not heard. I know he was moved from McAllister off death row to another institution in Oklahoma, I think near the Norman, Oklahoma area. But as far as is anybody still interested in buy things, or is there much of a push to keep trying to get him out of jail? I haven't seen a whole lot lately. So I think it's kind of passed. And I think it's been maybe 4 years since the governor commuted his sentence from death to life without parole.
Yeah. I mean, I think that was, it was interesting because I know you're very anti-death penalty, and Biden just commuted federal death row inmates, and there was a few that did not want the commutation from a death sentence to life in prison because they said they could have more resources, meaning the anti-death penalty, there's so much money on that side, and more of a chance of getting their case acquitted by being on death row. So, can you speak on that?
Yeah. Death penalty cases get much more scrutiny. They're really looked at through a very powerful lensed microscope. Whereas, somebody who gets life without parole, they just, tragic, but they don't really seem to give it that much scrutiny. So I can understand why, for that purpose, if they want to eventually walk away from whatever crime they committed that they received the death penalty for, and they're claiming actual innocence, it would be best if you were on death row to get that continued scrutiny. I mean, think about it this way: Richard Glossop, the Oklahoma case that Richard now is unheard of in American legal history. His case has been before the United States Supreme Court 3 times for 3 different issues. So if he was given a life sentence, we would have never heard of him again.
Maybe
So in a
that would
way,
be
the fact that he got
preferable.
the death, and he may very well, get out someday. I don't know what the Supreme Court's going to do with this latest appeal. I guess we will learn that in the spring. But it seems like it may be heading towards a new trial for him.
Oh no. And then they're at a huge, the state is at a huge disadvantage because it's been how many years? 20 years since he's been accused. He killed Barry Ventries via his co-defendant, I guess you could call it.
Yeah, I can't remember that young man's name, but yeah,
Richard Sneed.
Richard Sneed. Yeah.
No, it's not Richard. It's something. Sneed is the last name.
I think it was in 1995. Glossop was arrested just outside of my office. He had come to consult with me about possible representation, and had been followed by the police where they arrested him. So I spent the last 30 minutes that he was free with him. But I don't know as much about that case as I would like, but it looks like it might be heading towards a new trial. Is the prosecution at a disadvantage?
Wasn't he arrested right outside your office?
That's right. Yeah, he right outside the front door. I don't know if they're going to be at a disadvantage in this. I think the publicity that the case has drawn is going to make it very difficult, because it's pretty anti-prosecution. And one of the prosecutors on the case, Gary Ackley, is a very dear friend of mine and is ethical as they get. So I'm wounded anytime that there's some allegations against Mr. Ackley. I have tried 5 or 6 jury trials against him, and I can tell you unequivocally that he is a good man, a good, fair, and honest man, and would have never done anything to jeopardize Mr. Glossop's rights.
And Justin Sneed, it's Justin Sneed, by the way. Yeah. Mm-hmm. And they've been trying to blame it on him, did it alone, his own idea. Mm-hmm. And you have it's his conflicting statements and Richard Glossop. I mean, it's a very, you really have to know a lot about the case, but there's so much disinformation about that case. Like, he never had so much as a speeding ticket. When he got his license revoked, he had so much. Well, they really make him out to be a saint, Richard Glossop.
And in the actual innocence world, which is how I met you, not actual innocence, where they're guilty, but they're trying to show they're innocent via media. And what you have the term for? What is it?
Innocence fraud.
Innocence fraud. Thank you. And that's exactly what it is. And Glossop, I don't have an opinion on, but having been through the Julius Jones thing with stuff that's just made up, that never occurred, just fake news, it was incredible. And it was incredibly frustrating. The Making of the Murderer documentary, which I was really hooked on when I saw it. And then the Paul Harvey, Now the Rest of the Truth comes out. And I'm like, oh, that guy's good for it. What are we doing here? Why did I waste...
Stephen Avery, you mean?
Yes.
Stephen Avery? Yeah.
Yeah, why did I waste 7 or 8 hours watching that thing? And those people just lied to me by omission. And, it's
welcome
it's
to the world of true crime documentaries. They're pretty much 90% of them are like that now. Mm-hmm. You always have to ask yourself, what didn't they show me? Mm-hmm. Because it goes back to the West Memphis 3 documentaries where they can do 4 or 5 documentaries, but they can't show you that one of the defendants confessed multiple times. They have room for everything else but that, or the really salient evidence against them. So it makes our courts really look like we have kangaroo courts going on. Speaking of kangaroo courts, what do you do with bad judges? We had a ruling in this case that was, to my eye, looked incredibly wacky. You have a defense witness where he forensically looked at a phone and put a Google search date to a time when it was really just so say like you open up a browser and then you keep it open and then you look at another time, it will give the original date. So basically he was so wrong, basically, this defense witness, that they had to rewrite the program so people didn't make the same error. And the judge said, well, he's allowed to testify on the second trial because that's his opinion. She put that to an opinion and not a methodology or a fact. So, I mean, I thought I was like, well, what are we going to have flat earthers come in and say the earth is flat? And that's an opinion too. I mean, it seems like, what do you do when, as a defense attorney, with bad rulings, and how much do they affect your case? I mean, obviously the counter argument is, well, they can destroy him and cross, but it's that one juror that might be swayed by a piece of information. That's what I worry about.
Sure. What you do with a bad judge or a bad ruling is you make a record, meaning, you build into the record the case law and why the judge is wrong and all of that. You ask the judge to reconsider if that's appropriate. You ask to revisit it as many times as allowed without risking going to jail for being in contempt. But what you're doing by building a record is building, in case of a conviction, building an appeal. So I think what the general public doesn't really understand is they put judges on high pedestals. And I think in some jurisdictions, some places, federal courts, for instance, they should be on a high pedestal. They typically are smarter and more fair. But when you get to state court judges, they are people that typically could not make it as a practicing lawyer. They knew somebody who helped them get appointed, or they put their name on a ballot. It's not like you had to finish in the top 10% of your law school. You have to jump higher or run faster. Nothing like that. So you get some judges that are just really take your breath away stupid. So you try to prepare for that by explaining to them on the most elementary level what the law is and trying to get them to understand the law, which they've never understood before. Another thing about lawyers, there's nothing difficult about being a lawyer or law school or anything like that. It's just, you had the wherewithal financially and the family supports, so you could go to college for 7 years. There are some very low functioning lawyers and there's some very low functioning judges. So you deal with the judges as best you can by making a record. And if you know the judge is not somebody that's very bright, you educate them on the law. That's your job, to educate them on the law and speak to them at a level that they understand. They can be, the last part of your question, they can be devastating to a case. They can get an innocent person convicted. So your job is not only to zealously advocate for your client in front of the jury, but it is to zealously advocate and educate the judge, and don't take it for granted that they know something that everybody else knows, because they may not. And you have to know your ball field. You have to know who you're playing with, and ask questions about this judge. Where are they weak? Where are they strong? Where am I going to have troubles with them? Do your homework. That's how you handle it. But sometimes you just get some bad rulings and you have to push through them and do the best you can.
Yeah. Do you find that when I talked to prosecutor John Lewin, he said that he's found it most helpful as a prosecutor to know the evidence code inside and out? I mean, what's been most helpful for you as a defense attorney?
I agree with Mr. Lewin. You have to know the evidence code inside and out. You have to know what is admissible, what is not admissible, how to get particular pieces of evidence in, how to address objections that are made. And that is where most judges and lawyers are lacking. They don't understand the evidence code. And they don't understand it because of this. The American law school experience is very much lacking, especially when it comes to the course of evidence. It's typically a 4-hour course that does not go over every bit of the evidence code. It goes over certain highlights of it, like hearsay and admissibility and things like that, but there's so much more out there. And so you study for that, but you're not at all prepared for the courtroom setting. You study for the bar, which doesn't get you prepared for the courtroom setting. I like the English system of training a lawyer, where you go to school and then you're an apprentice for a while, for lack of a better term, and you get the hands-on experience. The evidence code, I'm sitting on my couch at home right now, and I'm touching it right now with my left hand. You hear that tap? That's the evidence code.
You got it always nearby.
I love the evidence code. I love learning new things. You have to be open to learn new things. And there's just so much of that evidence code that you're never going to come across. But you need to know it just in case you do, and to know the practical aspects of it, because not only is it, a statute, the evidence code, but then there's case law that interpret it. So you stay up on top of it. So the prosecutor, Mr. Levin, he spot on, 100% right. The only way you can be a good trial lawyer is to know the evidence code inside and out.
Mm-hmm. Yeah, that's interesting. And so, you brought up before, you said that, we were talking about these innocence fraud campaigns, pulling things out of thin air. I mean, you think when you have a guilty client, obviously the best outcome is to get some kind of acquittal. What would you say the second best is? What, a plea deal? Is that would be the best outcome, or I guess it depends on the case, right? I guess you may.
An acquittal is always what you're shooting for, but a lot of times you can negotiate a plea bargain that everybody can live with: the victims, the government, the defendant. But also in most jurisdictions, we have lesser included crimes. Let's assume you're accused of murder, which has a specific intent element, malice aforethought to kill. Well, below that would be, in the state of Oklahoma, manslaughter in the first degree, meaning that you committed the act in the heat of passion and you were so blinded by rage or whatever your passion may have been that you could not have formed the intent to kill under the murder statute. So sometimes you go to trial in a murder case and they get convicted of, say, manslaughter. Murder carries life without parole, or death in Oklahoma. Manslaughter is 4 years to life. So you can get somebody a sentence that they've taken a life that they can live with, and they can have a life outside of prison someday. That is a good resolution to a case many times.
And they're trying to get the second degree charge off of Karen Read, and in saying that the first jury all agreed that she should be acquitted, but they took it to the Supreme Court, so we're still waiting for a ruling. But that ruling could come way after the April 1st start date of this trial. That's these Supreme Court rulings seem to take forever. Is that regular?
Is it the Supreme Court of Massachusetts, or is it the Supreme Court of the United States?
Supreme Court of Massachusetts.
I'm sure the trial will be delayed if there's not an issue that important, if that wasn't decided before then. And if I remember this case correctly, that there's an implicit acquittal or something that happened, that they're saying that jeopardy is attached to that particular lack of verdict that maybe wasn't read in open court. And
Right. They're
if I,
saying that the jurors didn't understand that they could acquit on the charges that they all agreed on, but it's pretty shaky as to what happened in the jury room. It seemed like they were, to my ear, it seemed like they were just full stop deadlocked on everything, but we'll see.
Yeah,
but it's a very defense friendly state. We'll see what happens. So, does anybody have questions for Mr. McKenzie before we've been going for an hour. I guess my last question, ultimately I guess this is a case of using the media. Do you think if you had a case like this, let's say, where it was a very media heavy case and your client, could you stop your client from, you couldn't physically stop your client, right, from doing a bunch of interviews and did a bunch of interviews like this and you got a hung jury? What do you think it's been helpful, I guess, do you think the media can be helpful to have this kind of rabid support for your client in the public? It's public support. Does it leak into the courtroom?
I've never had a case where there's public support for a client, so that would be new to me. But I think what you can do and let's just talk about Colin Griffith. If he were to be charged in Oklahoma, there is a lot of bad news out there about him. And I think you would owe a duty to try to level the playing field a little bit and maybe address some of that pre-trial. And the rules of professional conduct allow for that. But to just go out there on a public relations campaign when you're not trying to combat everything, it becomes a problem of you're interfering with the deliberative process of the jury. And, the courtroom and juries are sacrosanct, and they should decide, their verdict must be based upon what happens in the well of the court from the testimony, the evidence, the rulings, the jury instructions. And to try it, as we say as trial lawyers, try your case in the media is not proper, but you do owe a little bit of a responsibility to at least level the playing field if you're getting beaten up in the press. And I think Colin is getting beaten up pretty badly. So if that ever comes about, then I will probably address some of those issues. But
how do you, you can't move it out of the whole state of Oklahoma. How do you mitigate those issues?
Well, how you would mitigate them is you would find the things that are being said that are untruthful. Okay. Like, I don't know anything about the Florida case other than he took his mother's life with a knife. Okay. And I read a little bit about it. I would like to get my facts straight on exactly what happened and address with the press what is or is not right with that. With regard to the factual scenario in Oklahoma, that he could be portrayed as just a homicidal maniac that's decided he would kill both parents. Well, I can tell you that what I do know about the father. There's a lot behind that story that is shocking, that is going to need to be addressed at some point should he be charged. And hopefully they won't charge him and they'll just go away and he will, can go on with his life.
Tammie wants to know how your three sons are, and are any of them attorneys?
My threesomes?
3 sons? Don't you have sons?
Oh, yes, my 3 sons. Yes, they are great. No, I have a son that's in medical school. I have a son that plays bass for the Flaming Lips. And in fact, I owe you an apology, Roberta, because I was in New York to see them play Madison Square Garden and I didn't call you.
Yeah, what's up with that?
I'm sorry. It was in and out. I went Boston, New York, Philly.
Good for him.
Yeah. And my youngest son is a freshman in college. So No, and unfortunately, they are not attorneys, nor do they want to be attorneys, and I'm very thankful for that.
It's a doctor.
A doctor.
That's good. If the defense changes, okay, hold on. Hey, Jude wants to know if the defense changes their defense from the first trial to the next, is the opposing team able to cite contradicting statements from the first trial, thus impeaching witnesses?
Under certain circumstances. Impeaching witnesses, certainly. If they say something different than they've said in a sworn statement or even an unsworn statement or even a TV clip, then you can confront them with that and impeach them, which is a very fancy word for calling them a liar. So yes, the more statements you make, the more ammunition people have to kind of cut you down. So yes, you could do it in a second trial.
Yeah, silence is really golden, especially if you're guilty. Can you tell us what was shocking about Colin's dad? Sunny-eyed girl wants to know.
Well, I'm not going to go into it a whole lot, but there was just unbelievable physical and psychological abuse. And I will tell you that he would not let that child go to school for 3 years and kept him at home. He did not, at the time that he was detained when the father was killed, he didn't even have a pair of shoes that fit him. Colin's a pretty good-sized kid. Last time I saw him, I'm going to say he was about 6'1" or so. And clothes didn't fit. It's just a horrible, horrible existence. But he was so bright that he immediately, even though he hadn't been to school in 3 years, caught up with his class and thrived in school and started college.
Well, that's got to be good for your defense, no?
If it's admissible, yeah.
Yeah, right. Anything else? I mean, I think we've done it. Anybody have any other questions? I'm going to close this out pretty soon. I've seen the Flaming Lips 4 or 5 times. Yeah, they put on a great show. I agree. I agree. It's a fun show. Okay, so I think, is anything else you want to say about, I mean, if lawyers, okay, so if it catches fire, right? And lawyers start doing these kind of tactics, these pre-trial tactics. Basically trying the case in the court of public opinion. How do you think that changes our legal system?
It's a horrible idea because that's not what we have to try things in a controlled environment, meaning a judge making rulings, a jury not hearing things that they shouldn't hear, and to try it in the case of public opinion is undignified. It's improper. It goes against the American system of justice and system. And I've watched trials in England. They have a very dignified way of doing things. So we're going to have to, if that happens, what we're going to see is we're going to see courts imposing more gag orders and shutting lawyers down on going out and talking about things. I've been in many cases that were high profile that the prosecutor and I would agree. We would self-impose on each other a gag order so that we're not out there trying it in the case, trying it out in the press. And I think that's the gentlemanly way to do it. And it preserves our system as it should be played out in American courtrooms.
What's a cross motion? What does that mean? A cross motion?
Oh, that's like I move for something to get something in, and then they move to keep it out. There's a lot of different interpretains on that, but yeah.
Okay, I'll have to ask you something personally. Hang tight after the show. I just have something quick to ask you. Tammie says, "Thank you, Tammie. Thank you, David. Learned a lot from you and Roberta. Wish you many victories."
Thank you.
Okay, so I think we've done it. Let me just double check. Okay. I think we've done it. Thank you so much, David McKenzie,
you're
for
welcome.
very candid and fascinating interview. I hope you'll come back.
I certainly will anytime. Thank you for having me.
Thank you. All right. I'm going to end the way I usually do. I'm also a songwriter now since we've last talked. I'm the most prolific AI music lyric writer this is my song about Karen Reed. Have a great night. I'll see you tomorrow, everybody, at 6 p.m. Eastern. Have a great night, everybody. Don't go anywhere, David.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and a witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom.